times people approach me and they ask me, can I write my own will? And I say, well, yes, but the real question is, should you be writing your own will? And that answer is no. I'm attorney Vernita Williams, and I want to share with you some of the reasons why you should not be writing your own will. Now, a lot of times people pose that question, can I write my own will? And I just wonder, why do they want to do that? Are they being penny wise and pound foolish? They don't want to pay an attorney $500, but they're going to pay $5,000 to straighten out the mess they create from writing their own will. So let me give you some specific reasons in this part 2 presentation as to why you should not write your own will. Now in part 1, I gave 5 reasons. This is part 2. I will give you 5 more reasons. Reason number 1, your will that you write may conflict with other documents that are in other places. For instance, let's say you write a will and say, give Brenda the $50,000 in the bank. But 10 years ago, you put a pay on death beneficiary form in the bank that says, give the money to John. Well, you think because you recently did the will, that will control what happens with the $50,000, but it won't. What is on file with the bank will control. That's how it works when you're doing estate planning. So sometimes people create conflicting documents and don't understand how that is going to play out. The second reason is related to undue influence problems. When people write their own will, they don't understand that if somebody who is encouraging them to write a will is going to get a whole lot of stuff out of the will and is going to serve as a witness, it's going to look like that person who wrote their own will was under what is called undue influence. If people are participating in the process and they have a lot to gain. So that's another problem I find with laymen doing their own wills. A third reason why is sometimes when a person who is not an experienced estate planning attorney prepares a will, they include an extensive list of a whole lot of personal things. Give this one the doll, and this one the china set, and this one my ring, and this person my shoes, and that one the piece of Tupperware, and give this one the 2 forks, and having all of that personal stuff in your last will and testament means that you are going to involve a whole lot of people having to come to court about all of these little items. That's not the way to dispose of personal items, not in your last will and testament. It should be done in a separate memorandum, but maybe you wouldn't know that if you're not an estate planning attorney. That's why I say don't write your own will. A fourth reason is sometimes a person who is not an estate planning attorney will not follow the proper format that is prescribed by the state statute. You know, every state has requirements about what they consider to be a valid will. Florida requires there be 2 witnesses, a notary, that these people have to sign at the same time. A lot of times when laymen do the will writing process, their witnesses and their notary don't sign at the same time. One of them signed at choir rehearsal. The yard man came over to do the yard. The next day he signed. And you have all of these different signing settings, which makes the will subject to challenge and being declared null and void. A fifth reason is sometimes people don't really understand what they're trying to do. I've known of people who tried to do a trust, and they thought you do a trust the same way you do a will. They did not do what you call fund the trust. So they drafted a document, they had witnesses, they had a notary, they executed it, but the property that was supposed to be placed in the trust was not done. They didn't know that they needed to do a trust deed. So it's so many details in the estate planning process that you just won't know if you don't practice law. You have a good understanding about what you want to do for yourself, but you don't really understand how to put it together to make it work the way you want it to work. So my recommendation is do not write your own will. It's not because I'm trying to make you go spend money with an attorney. It's because I'm trying to encourage you to set up something that's going to work for you. So if you would like additional estate planning tips and a checklist of 25 things you can do to set your affairs in order, please visit my website at vcwlaw.com. That is vcwlaw.com. And there you can get 2 free downloads of very, very helpful information. Also, if you would like to call me with your questions, comments, or suggestions, you may do so at 786-831-9483. That is 786-831-9483. Thank you for listening.